Let's look at this court's decision in depth and the possible implications with legal expert Mpumelelo Zikalala. Kuzen, good evening to you and thank you so much for your time. Let's begin then with this very ruling, because listening to what Judge Matujane has to say, he admits and says that a different court may reach a different conclusion. One of the things that he says in his judgment is that another court may find that because of his illness and age, the former president needed to be shown compassion, empathy, and humanness, the essence of Ubuntu, and also talking about this decision that he is simply a beneficiary of a decision that was made by the Correctional Services Commissioner. I'm listening to this judgment. I don't know if those that are interpreting it as Judge Matujane conceding that his judgment may not be as watertight as some have thought that it could be correct.
Good evening, Manget, and also to the SABC listeners. You are definitely correct. He is saying indirectly, I may have been harsh in saying to the former president he must go back to jail. In fact, this is not a decision that he took voluntarily. This is not a decision which rested upon him. So he did not walk out of Escort prison on his own. He was doing so under the impression that the relevant body, the relevant authority, been given the power to grant medical parole, had thought this particular matter through. All the decisions were in strict compliance with Section 33 of our Constitution. Hence, everything was done according to the law. Now, if it is found that it was incorrect, he shouldn't be punished for a decision that he didn't take. So in terms of being compassionate and in terms of having Ubuntu, that is the part of Ubuntu that the judge was alluding to. We must also look at the term of detention, the wider interpretation of what does it mean to be exactly to be detained. You are not enjoying your freedom as you would want to. You can't go maybe abroad or to an overseas country for a period in which you are still under detention. So technically speaking, he is still a prisoner. Technically speaking, he is still under the supervision of the Correctional Services Department. So we can then punish him the second time by saying, because the decision was taken incorrectly by someone else, not within your control, then you must suffer the consequences of that decision. I think that's what the judge was saying when he said, let us look at compassion and Ubuntu and see whether we can arrive at a different conclusion.
Now, I'll get to the part about the sentence in just a moment, because that is another area of criticism that we heard coming out very strongly, shortly after that judgment. But I really want to have this follow-up question for you so listening to what you're saying and to what we heard earlier on, could it then be maybe a case of if Judge Matujane was in a position to rescind parts of his judgment, he could have? Was that something that he may have been signaling?
He could have done it after reconsidering his stance. But let's also remember that the avenues in which you approach the court, if you say that the court must rescind a particular judgment, you then say there is an error when it comes to the law which was applied. The strict application of that means that you are meant to look at this particular legislation or this particular section, however you looked at another. Hence, you've arrived at a different conclusion. Now, if the particular piece of legislation is correct, it's just that in your application, there's a certain level of discretion that you didn't apply due to the blurriness of the line when it comes to how that particular provision should be applied. The perfect way of doing it is to deal with it through the appeal process. Let us further remember the instances or the elements of seeking an appeal. You are then saying, you have all the relevant facts at your disposal. Meanwhile, you've come to a conclusion that a reasonable judge or a presiding officer would not have come to, because you haven't considered certain facts or certain points. That is what he was saying at the end of his judgment, saying that, yes, those facts were within my disposal. However, I did not consider his age. I did not consider the element of Ubuntu. I did not consider the element of compassionate. So on that basis, the processes evidence that you brought to me was correct. However, there's a bit of a shortfall in my judgment in application of those to the relevant law. So please go to the SCA. The SCA will be able to direct it to the correct provision. But I do think the Concord is going to be the end, the last point in which we are going to arrive at, because the things in question, the interpretation which are required, they are so of national importance and public importance that they can't simply end at the SA. We need finality on them so that we don't have a repeat of what has happened in this particular case.
So, listening to what you're saying, then, you look at the former president's lawyers' papers, and part of the argument is that there is no correctional facility that will be able to look after him and make sure that it grants him the 24-hour care that he so requires. And also, that is another argument that is also being backed up by the Correctional Services Department themselves. Could we see the SCA coming to a different conclusion here?
We can see the SCA coming to a different conclusion. However, it will depend on the evidence that has been provided. To simply make an allegation not backed up by any facts or medical reports that says this is the nature of the illness that you are dealing with, this is how it is handled. If it is not handled properly, these are the dire consequences which the person suffering from the illness will suffer, which is the ultimate one is death. So if we do not provide these precautionary measures, this is what is going to happen. Without that, at the hands of the SCA, then it means that that particular argument can't be traversed. Let's also remember, the stage of submitting new evidence has come and gone. So if you go to the SCA, you are simply supplementing and providing legal submissions based on what has already been submitted earlier. So when you look at the facility, you are then asking yourself this question. Based on the illness that was provided to me earlier, do we have facilities that can be able to provide the health care required by the former president in this case? That would be the first question. Second question, when it comes to physical incapacity, is he such of physical incapacitness to such an extent that he can't even take care of himself based on the decision of the illness that he has? If the answer to that is yes, then medical parole should have been granted. However, if evidence is provided proving all the 2 points as not being available, we are then proving the independent medical parole board doctors correct, and you are then saying this person should have not been released on medical parole in the first place. However, we can't punish him due to the fault or the misjudgment of Mr. Fraser. Let us give him the benefit of the doubt in the interest of justice and release him. But as a matter of principle, as a matter of precedent, we must make sure that we're able to space these particular issues clearly and state this is the formula that a commissioner in the shoes of a Correctional Services Commissioner is supposed to assess and use when determining whether one should be released on medical parole or not.
Khuzani, very briefly, we're almost out of time. Could the developments that we are seeing in this particular case have an impact on the case that's currently, supposed to be, in fact, that's currently unfolding in the Pietermaritzburg High Court against the former president as well?
Maybe in the near future, if the former president is found guilty, let's remember, once you submit anything in court which is on affidavit, it's a sworn statement that can be used somewhere else because it was stated under oath. So you may find the lawyers of the former president playing it safe in saying we're only going to disclose information which is relevant for this particular matter. We're not going to go into detail because we might use it at a later stage and you don't want to be boxed in on the evidence that has already been submitted earlier. Secondly, we're dealing with medical issues which are private and confidential. We don't want it to be leaked in the hands of the public. We don't want it to be leaked in the hands of other people that may use it for other reasons. So we are only going to answer on the issues which are at hand, detailing that from the position of the former president, he is simply saying, I made an application as a prisoner. My application was considered, and the only response that I got was that my medical parole has been approved. Whether it was taken incorrectly or correctly, that is an issue in which Correctional Services is supposed to deal with. Do not tamper with my rights, and make sure that there's no prejudice that I'm going to suffer just because Correctional Services took a wrong decision.
All right. Thank you so much for your time this afternoon. That was Legal Expert Mpumelelo Zikalala.